Today I wanted to dive into a unique and attractive coverage provision related to non-subscriber insurance: mediation arbitration. Mediation arbitration means that a suit won't be tried in a court of law determined by a jury. It will be determined by an arbitrator after a mediation hearing. As far as relating to non-subscriber policies, the Federal Arbitration Act of 1934 says that the employer may elect for employee-related disputes to be handled via mediation arbitration. Since the mediation process runs 3 to 6 months and a typical court case lasts 3 to 5 years, mediation legal fees are fractional and can save the insured a ton of money. So employers love this, right? Most do, but there's one catch. The arbitrator can make a ruling just like a judge, and this ruling cannot be appealed. In binding arbitration, the arbitrator's decision is final. Business owners who cherish the right to appeal should seek a non-sub program that does not mandate mediation arbitration conditions. One more thing about mediation arbitration. In the Federal Arbitration Act of 1934, there is actually no requirement for the employee to accept, agree, or sign off on this provision. The employer simply must be able to prove that he informed his employees that disputes would be settled by mediation arbitration. Now, of course, the best way to do this is to hold a meeting, explain the arrangement, and get everyone's signature. Well, what if one employee decides that they don't want to sign? In my opinion, the best way to handle that is for the employee's supervisor to write at the bottom of the employee's agreement papers, "Employee refused to sign." Then the supervisor and another witness sign and date that statement. If thereafter the employee stays long enough to receive his next paycheck, he has made himself subject to mediation arbitration terms. Well, there you have it, mediation arbitration for non-subscribers. I'm David Recadre and Associates, and thanks for watching.